Welcome to Legal Lines. This program is brought to you by the York County Bar Foundation. My name is Tom O'Shea. I am the host of the show, and today's guest is Audrey Woloshin, an attorney with the law firm of Ream, Carr, Markey, and Woloshin. The topic is child custody law today, and Audrey is a special guest because she serves in several capacities with the York County Judicial Center with respect to custody cases. Audrey is a custody conciliator, a custody mediator, and she also serves as a parenting coordinator. And we're going to talk about each of those roles in a few minutes, but first I'd like to welcome you to Legal Lines.
Thank you.
And while we're talking about these topics, let's talk first about custody conciliation. You are a conciliator. Could you tell the audience what that means?
Well, conciliation is the first stop that parties have in custody cases when they file a custody action. And a conciliator, there are 5 of us in York County. We are all attorneys, and we serve on a different day. And the parties and their counsel appear at a conciliation conference. And the conciliator's role is really to, in the first and foremost, to try to get the parties to reach an agreement. If the parties can reach an agreement at the time of the conciliation, we dictate an order. The parties sign a consent saying they've listened to the terms of the order and they're finished, and they now have their custody order, they have their schedule, they have their rules and their guidelines, and they can proceed on to parent their children.
So basically, if one parent files a custody action against the other parent concerning minor children, the first stop, if you will, if they don't reach an agreement on their own, is with the custody conciliator.
Correct.
And one day a week, that would be you.
That's correct.
And I assume that the parties do not have a choice as to which conciliator they get.
That's right. The attorneys take their petitions to the court administrator, and they are assigned a conciliator. And I think the theory is it's supposed to go in order, as they come in. Okay. They get the next available conciliator.
Approximately how much time does it take from the filing of the petition until the conciliation conference?
In York County, I think one of the things that the court system prides itself on is how quickly people get before the conciliator. So typically it would be 2 to 3 weeks.
Okay, so within 2 or 3 weeks there'll be a conference. The conferences last about an hour?
An hour set aside for each of them.
Right. And both parties would appear at that conference with their attorneys?
Correct.
And this isn't a formal court hearing?
No, it's an informal conference, and as I said, the first goal is to see if the parties can reach an agreement. And if there seems to be an indication that can be accomplished, we'll spend most of the time just going through all of the different terms and trying to hash out and customize the agreement to fit the parties' needs.
Let's talk about a couple of the terms, because I know in custody law there is something known as legal custody, and then there's also physical custody. Can you explain legal custody and physical custody?
Legal custody is decision-making. And in York County, the way I explain it to the parties in conciliation to the parents is that the court's going to give every parent in York County pretty much the opportunity to have shared legal custody, and that is making major decisions concerning the child's life. And those decisions typically involve education, medical decisions, religious decisions. So when you have shared legal custody, that means that the parents must jointly make those decisions together.
It doesn't mean they necessarily have to agree all the time, because sometimes parents who are living together and married and still can't agree all the time.
That's correct. They don't always have to agree. However, in order for legal custody to work, there has to be communication. You have to have discussion, and sometimes disagreement is healthy as long as you can communicate that in a mature adult manner, because different people have different points of view, and they all have to be taken into consideration. The other aspect of legal custody is information sharing. Each parent has the right to have notice of all medical appointments, parent-teacher conferences, important things happening at school, activity notices, report cards, and things like that. And our legal custody provision that we include in all of our custody agreements and our custody orders sets forth that each parent must provide the other parent with that information upon receiving it. So each parent has the opportunity to attend those events and participate in the decision-making process.
Okay, so in most cases, legal custody will be shared by both parents.
That's correct.
Then we talk about physical custody.
And physical custody is time sharing. You know, that's the schedule. Who is the child going to spend nights with? Who's the child going to live with during the school year, during the summer? So physical custody is the time sharing arrangement.
Okay, and is there a policy that the court has adopted with respect to how time should be shared?
The court, well, it's not really a policy because under the law, the court must undertake a case-by-case analysis of each family. But the court would like to be able to award shared physical custody, especially when we're talking about preschool-age kids. In most cases, if the facts warrant it, and typically you're going to be hard pressed to have facts that wouldn't necessarily warrant it. Although there are cases in which that happens.
And that could be something like a job schedule where somebody works nights all the time, or travels a lot for work.
Right. Some parents are just not able to exercise shared custody because of their other commitments. But the court really does try to maximize both parents' time with the children, and sometimes it works with work schedules, and sometimes parents are competing, to spend the same time with the kids because their work schedules are similar. But I think just as a concept, we do tend to favor shared custody whenever possible.
Okay. And you said that, especially with children not yet in school, is there a consideration that changes once the children are in school?
Yes, because when the children attend school, obviously they're going to attend the same school all the time, and if you've got parents that that live in different school districts, that could become an issue. And the court won't pick a school. If parents have shared custody and it's time for the children to attend school, and the parents come to the court and say, we like our shared custody arrangement, we just can't select which school district the children will attend school, and the court will say, well, we're not going to pick a school. We will make a custody determination, and there will be a determination made that one parent or the other would have primary physical custody, which means that the children live with the primary custodian the majority of the time during school year. And the schedule can be the same, or it could be a different schedule in the summer, depending on the circumstances. Okay.
So your number one goal at the conciliation conference is to see if the two parties can reach an agreement.
Correct. And just in that vein, when you're talking about school issues, if the parents can agree which school the children will attend, they can agree to have shared physical custody, even though they do live in different school districts.
And it's my understanding with most school districts, as long as one parent lives in the school district 50%, or the child lives in the school district 50% of the time, the child can attend that school without paying a tuition.
That's been my experience. That's been my experience.
So if you have two parents with equal custody, the child could attend either school district if the parents agree. But if the child is in the school district of the parent who has less than 50% of the time, many of the school districts charge tuition, even if it's a public school, for the child to attend that school.
That's been my experience.
Okay, so that is sometimes a factor on getting the parties to agree with school-age children. And then it's something that I hear frequently, that people believe that there's this magical age out there where the child gets to decide. Is that true?
No. And I think 12 is probably the age that most people think the children are automatically have all of this wisdom. But in Pennsylvania, one of the factors that the court must consider is the preference of the children. At conciliation, our conciliation orders require children 7 and above must attend. And if the parents wish the children to speak to the conciliator, that typically would happen at the conciliation conference. And that happens with the conciliator and the children. The parents are never in the room, and counsel, the attorneys for the parents, typically are not in the room. But
so if a child has to speak to the conciliator, the child does that without both parents sitting there listening to every word.
That's right.
Okay.
Now, when beyond conciliation, if a judge is asked to make the determination after a trial, the judge will speak with the child, and there is no age limit on that. I've been involved in cases in which the judges have spoken with 5-year-olds as well as 16 and 17-year-olds. It's the weight of the children's preference that is the determining factor, not necessarily how old they are. The person, the trier of fact, who is the judge, will consider the maturity of the child, the reasons the child is setting forth for his or her preference, and determining how much weight that child's preference is going to be given in the ultimate decision.
Okay. Now let's say that you have the conciliation conference and the parties do not reach an agreement. What is your role then?
At that point in time, I will ask each of the parties to give me a brief summary of what it is that they would like to see the court do for them, and a brief summary of the reasons. And at that time, what the conciliator does is they make a recommendation to the court as to what the custody arrangement should be in the meantime until the parties have the opportunity to go through the system, which we're going to talk about some of the steps that they have to do after conciliation to get to a trial, at which time the judge will listen to the evidence and then make the ultimate decision. The first thing that the conciliator is to look at is what's been happening. We're supposed to look at what the status quo has been and try to maintain some consistency for the children. The difficulty comes in when this is parents that come in that are newly separated, who have not really established the status quo, that the conciliator's recommendations become difficult because you don't have anything to base it on. And the court has taken the position that typically you determine a status quo by what's been going on for the last 6 months, give or take. Because we really don't want to reward parents for rushing to the courthouse steps to get there first to establish who's got primary custody. So if it's a new separation, we're kind of starting from square one and try to look at what would be in the best interest of this child, for the next few months until you get to court. If it's a separation that's been in place for a while, we'll take a look at what the parents have been doing up to that point in time and try to tailor the order around that.
The policy would be not to disrupt what's going on with the child until the case goes to trial, but to put something in place for the child and the parents to follow until the trial takes place.
That's right.
And right now we're out of time for our first segment. We'll be back in a few minutes. My guest is Audrey Woloshin, and this is Legal Lines. Welcome back to Legal Lines. My guest today is Audrey Woloshin. Audrey is talking about custody, child custody, that is. I have Audrey as a guest because she serves in several capacities with the York County court system. One is custody conciliation, which we talked about in the first segment of the show. Audrey also serves as a mediator and a parenting coordinator, and we're going to talk about those two roles in this segment of the show. But first, let's go back to the conclusion of the custody conciliation conference. The parents did not reach an agreement, and now there is an interim order with a schedule they should follow until the case goes to trial.
Right.
Are there other conditions that you put in the interim order?
We put in provisions allowing the parents to obtain tests and evaluations such as psychologicals or drug testing if they wish to pursue that. And one provision that goes into almost every order, including orders in which the parents reach agreement, is that they must attend a custody workshop that is offered by Family Child Resources. It's a 4-hour workshop that everyone is required to attend. And it basically gives parents some good basic common sense type information, but sometimes that kind of information needs to be reinforced in these situations. So they're all required to do that. In high conflict cases, there's another workshop that Family Child Resources offers, the Cooperative Parenting and Divorce Workshop, and that's a much more intensive workshop that goes into much more detail concerning communication skills and things like that.
So the regular workshop is 4 hours?
4 hours.
And the intense workshop?
I believe it's 2 hours for 8 weeks.
Okay. Now, in addition to that, if the parents do not reach an agreement, the court strongly suggests or requires, I should say, that the parties attend mediation.
That's correct, except in situations in which there are protection from abuse orders that have been entered within the 2 years surrounding the custody action. Everybody will be required to attend mediation. And mediation is another structured process in which the parents get together with a third party, but the difference is that their lawyers are not present, and the third party is a trained mediator, and that person's role is to help the parents facilitate and direct their conversation and identify the issues in another effort to try to reach an agreement.
Okay, so the parties go there without their attorneys.
Right.
And this would happen after the conciliation conference. And just one disclaimer, if you happen to be the conciliator, you do not also serve as the mediator for the same couple.
That's correct. And we have a list, and right now our list is growing of the court-appointed custody mediators, and I believe right now there's 8 or 9 mediators on our list.
All right. So the parties are then directed to meet with the mediator before they go to a trial, which sounds to me as though what the court's policy is to try everything possible to get the parents to reach their own agreement instead of having a custody trial where the judge has to force an order upon them.
That's right. And when I talk to my mediation people, it's easy for me to sit there and say, this is the last-ditch effort to put you again in a room together to try to resolve it. But I have to qualify that because it's never the last-ditch effort. A custody case can be settled at any time. Even on the courthouse steps, or even after you've entered the courthouse and completed your trial before the judge has made a decision, the parties are encouraged to try to enter into an agreement. So the court will do everything in its power to try to make the parents come to their senses and maintain some control over the outcome of the case, because once the case goes to the judge for the judge to make his or her decision, the parents lose all control over the outcome.
Okay. And do you have any statistics on how successful mediation is for the parties requiring mediation?
It's about, well, we'll start with conciliation. Traditionally in York County, we've settled approximately 50% of the cases at conciliation. And then of the cases that do go to mediation, I think we're settling between 30 and 50% of those. And, you know, it really depends on the quarter that you're looking at. But we have a good rate of success in all of these pre-trial attempts at settlement.
Okay, so then only much smaller percentage of the cases filed ever wind up in a full trial in front of the judge.
Right.
One other thing I'd like to point out with mediation, is it possible for people to try mediation before ever filing a custody case?
Yes, it is, and it should be encouraged. And sometimes as part of the agreement in these cases, the parents will agree that before they file another petition for modification or for contempt because they think somebody's violated the order, they'll be required to attempt to resolve whatever dispute it is that they're having at mediation before they even enter the court system at all. So, and if the parents do go to mediation voluntarily, typically the court will look upon that and they won't require them to do it again if they're not able to resolve the case.
Okay. Well, you point out something interesting where you're stating that a petition for modification. custody by nature is always modifiable. Am I correct?
Right. We talk about final orders, but it's never a final order.
So if somebody has a custody order now, either because they agreed to it or because the judge ordered it, in the future they have the right to re-petition to change the order.
Right. And the standard always is what's in the best interest of the child at that time. And
if I'm correct, the theory is that the needs of the children change, situations change, therefore custody must be modifiable to look at the best interest of the children at whatever time the new case is filed.
That's correct.
And if a new case is filed, it goes to the conciliation first.
Right.
And if they don't reach an agreement in the conciliation, it will go back to mediation.
Right.
And then ultimately a trial where the judge makes the final determination that basically everyone has to live with, whether they want to or not.
Right.
And in most cases, what we're looking at in a custody order is a schedule.
Right. And I try to explain that to parents, both in the conciliation and the mediation, because people come into court wanting the court to fix what they perceive as a problem with the custody arrangement. And all the court can really do for people is provide them with a schedule. And that's not always the issue. Many times the schedule is not the problem. It's that the parents are having a difficult time communicating with each other and communicating information that each parent needs to know, has a right to know, so one or the other starts feeling like they're left out. And we can tell parents, and the court can tell parents, you must communicate better, but it's really up to the parent to implement that. And fixing a schedule or modifying it or giving somebody primary custody or shared custody isn't going to fix a communication problem. And it doesn't matter what your custody schedule is. It can be a 50-50 schedule. It can be a more traditional schedule where a parent has alternate weekends. You still have to communicate information about the child's life to each other.
That brings me to your third role, and that is of a parenting coordinator. Could you tell us what a parenting coordinator is?
Well, a parenting coordinator is a person who is empowered by a court order to assist parents, and I shouldn't say empowered, we're authorized. Our role is to assist parents in implementing their custody orders, in developing and learning communication skills, in mediating disputes that arise from time to time. And if the parents can't reach an agreement or on their own, then the parenting coordinator has the authority to render a decision on particular issues. And they're typically issues that involve a child's day-to-day lives, activity issues, vacation issues, temporary variations from a custody schedule, communication issues. What a parenting coordinator cannot do is change the legal custody arrangement or make substantial permanent changes to the custody schedule. And a parenting coordinator really should only be utilized in cases in which there is a very high level of conflict. But there are quite a few cases out there in which the parents engaged in a high level of conflict regarding a number of issues.
Could it be, in some cases, there's a lack of communication, in other cases, there's too much communication, but it's ineffective communication?
That's a really good way to put it, because I have several cases in which both of those scenarios apply.
All right, so can you give an example of an issue that the parenting coordinator may become involved with?
I have become involved in issues regarding custody exchanges. We have to develop different manners in which parents can exchange custody because they can't do it in a public place, because there seems to be altercations there, and it becomes difficult to do it at daycare providers. So we've implemented different schedules and rules concerning how parents will exchange custody of the children. Activity issues seem to be a popular topic for parenting coordinators, because oftentimes parents become very much enmeshed in the activities they wish the children to participate in, and they don't always agree. And sometimes the children want to participate in those activities, and sometimes the children have their own ideas of what kind of activities they want to participate in.
And some of these activities require very demanding schedules that could impact the time that the other parent has with the child.
Right. And when can a parent schedule a vacation? Because many times these activities, especially these travel sports teams, require attendance during the summer on most weekends, and if a parent is not engaged in that activity, they become very defensive and want to be able to have some authority and control over spending family time with the children. I've become involved in situations in which communication has broken down between the parents and professionals, such as counselors and doctors. And many times I've become involved in coordinating services for the child, such as getting the children into their own individual counseling and getting the family into family counseling.
So if the parents do not agree, then ultimately you have the authority to make the decision for them?
That's right. That's right.
And there's a court order that gives you that authority.
Right. And if the parents are not satisfied or happy with a particular decision, they do have the right to request the court to review that decision.
So there's sort of, if you will, an appeal process.
Right. Right.
Okay. Well, we're almost out of time here. I want to thank you, Audrey, for coming on Legal Lines. My guest today was Audrey Woloshin from the law firm of Ream, Carr, Markey, and Woloshin. We were talking about child custody. My name is Tom O'Shea, and this was Legal Lines.